right, good afternoon, business law students for the summer. Hope everybody's doing well. We're moving on into chapter 9, and we're going to be looking in this chapter a little bit on what's called, or as your book titles it, capacity, legality, and enforceability. One of the big areas always with contracts is, you know, did the parties have the capacity to enter into a contract? Are they legal? And then really what that is centering around is the idea of enforceability. So, if one party says, this contract shouldn't be enforced, and the court's looking at why might that be, and they're seeing evidence that there was some issue of capacity or legality, then that's going to raise some issues. Because always keep in mind that, I don't know if I've said this yet, but a large majority of contracts that are entered into the business world go off without any problems. I mean, most of the time when you're in business, a lot of your contracts are with partners that you have an ongoing relationship with, and even if there's a glitch here and there, you basically work it out without threatening lawsuits or damaging that relationship. It's not unlike, if you've got a friend, um, or you have friendships, there's going to be arguments and disagreements, but that doesn't mean you end the relationship. And people make concessions. So parties in business often make concessions. So just kind of keep in mind that even though disputes do arise, obviously, and litigation does happen in the world of contracts, a lot of contracts are entered into, they go off without a hitch, and then even if there is a hitch, then they're resolved. So just kind of keep that in mind if I hadn't said that before. All right, let's talk a little about contract capacity. It's the legal ability to enter into a contract. One of the things too that is, a lot of this I just want y'all to kind of be aware of. You know, we have we live in an era where, especially with the online proliferation, online platforms, teenagers, excuse me, being very tech savvy and entering into essentially contracts online, the question then becomes legality. And um, basically, minors aren't really in a position to enter into legally binding contracts. Now, do they? And do companies follow through with it? Do the minors end up holding up their end? Of course. But if it ever became an issue legally, there might be some problems, with that contract. So one vocabulary term I want y'all to know is disaffirmance. Disaffirmance is the legal avoidance, or essentially setting aside uh, of a contract or contractual obligation. So basically, it allows minors to have sort of a safety valve to get out of the contract if they since they lacked the true capacity. Um, all right. Another type of another word category I want y'all to be aware of is intoxicated persons. Um, you know, a contract that is entered into may not be valid if the person was under the influence of drugs or alcohol. So for instance, there's been a lot. I know some of y'all are probably laughing, like, are these actual real world scenarios, Professor? Absolutely, because you can imagine, take a city like Vegas. All right. A lot of gambling goes on, a lot of alcohol, drug consumption of one type or another. And let's say you have a car dealership, and somebody goes to a casino and ingests large amounts of alcohol and or other intoxicants or drugs, and then they go and they're entering into some sort of contract to buy a very expensive sports car. And then they realize what they did the next day, and there's the car dealership says, hey, we want our money, and the person says, well, wait a minute, I don't even remember entering into this. And they and it it could become a lawsuit. But obviously, if someone's intoxicated, their ability to make rational, informed decisions is impaired. So obviously, in a situation like that, um, the the transaction may be voidable. And so a lot of it's going to come down to is what did the other side know or have reasonable expectation of. So if someone comes in, and if you're a car dealership in the Vegas area, you probably have a pretty good idea that a lot of people are going to come in under the influence and potentially be open to making decisions that they would not normally make if they weren't under the influence. Mental incompetency is a big deal as well. If someone's suffering from some sort of cognitive degeneration or advanced aging, um, something of that nature, that's going to call into question about their ability to enter into contracts. Um, and that's where you get into the whole realm of powers of attorney and who's making decisions on someone's behalf, etc. So intellectual or mental disabilities can definitely impact um, contracts from a legality and enforceability standpoint. um, that's why when you get into the realm of wills, trusts, powers of attorney like that, I think even your ebook um, kind of uses some hypos of that. I mean, these are real world scenarios that come up. So, if you're doing any kind of estate planning, you want to make sure that whoever you're designating to be your power of attorney, your guardian, in the event of some sort of incapacitation, is going to be making decisions that are in the best interest of you and your money, your assets, and everything else. So, something to keep in mind. A lot of people don't really think about that until the situation is upon them. Okay, legality. Um, Remember that this is one of the key points of, do you have a valid contract? And you have to have there has to be legality with it. In other words, you can't enter into contracts for crime, so to speak. Um, and then another area that comes in are what are called contracts contrary to public policy. And you will find often in the world of law that there are certain activities or behaviors or conduct that are simply contrary to public policy. And that is a very broad term. Um, and so you can't enter into contracts, for something of that nature that violates either the law or is just contrary to public policy. Because there may be instances where certain behaviors are not covered necessarily by the law, but they're still contrary to public policy, and the court is not going to enforce them. One good example that comes out of this area are what are called non-compete agreements, or covenants not to compete in employment contracts. So in today's world, especially if you're working in a sector like high tech, um, something where there's a lot of proprietary information, and businesses don't want people coming in, having their employees leave, then taking that knowledge and that skill set or that technology and going somewhere else to a competitor or starting their own business. And so a lot of times you'll have to end up signing what are called non-compete agreements. And obviously, in the world of employment law and business law, you can see both sides of it. On the employer side, you don't want to risk losing your ability to compete effectively. You don't want people coming in and basically stealing your hard-earned information and work, and then allowing other businesses and entities to profit by it. However, on the employee side, you also have to be, I mean, who wants to work at a place where they're gonna have to sign a contract saying if you ever leave, you're not gonna be able to work in this area anymore? That's not fair, and that would be a good example of contrary to public policy. It's not really illegal to, well, let me just put it this way. It A business could hope for that. They could wish that their employees wouldn't leave, but they're not going to be able to legally prevent them from going and making a living and taking care of themselves or family, etc. That would be contrary to public policy. So, non-compete agreements are very common in employment contracts. However, there's a balancing act to that, and they're generally legal, but they have to be for a reasonable period of time, and geographic restrictions have to be reasonable as well. So there's a reasonableness aspect, and reasonableness comes up a lot in law. The reason they call it the reasonable person or reasonable entity type of perspective. And so you can have non-compete agreements, but they have to be reasonable in nature. So if somebody just can't leave and then turn around and go to their competitor, you can't just leave Javaland. Javaland had come up with a special brewing thing and then take it to Starbucks or something like that. I'm just using some example. But this comes up a lot, especially for higher ranking employees or employees with special technical skills, or developers. All right. Let's see. Another term that I want you to know, I don't know if you can hear it, but my kids/kitties are trying to get into the office. They do not like to be locked out. All right. So let's kind of talk about another term called reformation. Basically, when courts are confronted with some issues about a contract, they may engage in what's called reformation. And it's basically a court-ordered correction to a contract, so that it basically tries to get a more balance and reflection of what the parties are trying to intend to do. Basically, trying to just make it to where be reflective of what the intention and the goals are. So reformation. And I've seen that in law a few times when there's some dispute about how a case resolved, or it basically there's some dispute about how a final order in a case reads, and the court, to avoid unnecessary litigation, will just say, okay, this is what we're going to do. I'm going to reform the judgment to reflect what the intention of the parties were in this agreement. Okay, so that's probably a pretty good example right there. All right. And then your book also goes into and talks about unconscionability, which is basically where a contract or terms of a contract are grossly unfair or unworkable. And so if the court looks at a contract or terms of a contract and feels that a party was basically taken advantage of, then unconscionability may come into the equation of how the court's going to deal with it. And your book goes on to looking at different types, including substantive, and procedural. Substantive unconscionability is the contract or one of the terms itself is actually overly harsh or violates the unconscionability principle. And then there's also procedural unconscionability, where the way the contract was written in some way was unfair. So these are just some of the terms I wanted y'all to be aware of. Again, not trying to get into too much detail with this, because you can really get into the weeds with it. But I like to give my students a little bit of just the vocabulary and sort of just the mental concepts of how courts are going to evaluate this. So there is a desire, the way that I always like to explain it is, courts want contracts to be enforced if at all possible. But they also want contracts that, to the extent possible, are going to be fair to the parties and reflect what the actual intent was. So you're not having one side take advantage of the other. Okay. All right. Your book goes on to talk about mistakes in contracts, and when we're talking about mistakes, It kind of depends on who was mistaken. So basically, if you are looking at bilateral mistake, okay, like where both sides were mistaken. Let's say I'm looking out my window and my neighbors have a new fence, and let's say that they wanted to get their fence painted, and they were mistaken on one aspect of a contract with a fence painting company, and the company was mistaken what type of fence it was, so they misquoted. The person thought they were in. I mean, it was just a mess on both sides. Then the contract can be rescinded by either party. They can basically just both walk away. It's called a bilateral mistake. And the other part could be a unilateral mistake, where one party is mistaken. And if one party is mistaken, well, unfortunately for them, then the contract is enforceable unless the other party knew or should have known that that mistake was made, or the mistake was due to some substantial mathematical error that would cause gross unfairness inside the contract. For instance, let's say that the person, the my neighbor wanted their fence painted, and the estimator comes out, takes the dimensions, everything else, and what should be $1,000 job, they quoted 100. They just misdid it, and my neighbors should have known that they weren't going to get their huge fence painted for $100, and they don't say anything, and then try to capitalize on that. In that type of unilateral mistake, then you are more than likely not going to be able to benefit from that type of error if you're my neighbors. All right. So let's see. Your book goes into looking at fraudulent misrepresentation. We're not really going to get into that. Obviously, there's also carve outs for enforceability of contracts where someone's voluntariness or their free will is being impacted. So undue influence or duress. In other words, you can't hold a gun literally or figuratively to someone's head to make them enter into a contract. That's a concept that is well founded in many areas of law, including criminal law. For instance, on the criminal aspect of it, if somebody, is holding someone, at gunpoint and forcing them to commit a criminal act, that's a defense to their criminal conduct. It's called duress. So that's a concept again that resonates through many areas of law. All right. Now, one thing I do want y'all to know that's really important is called the Statute of Frauds. Statute of Frauds. FARUDS. And Statute of Frauds is a very legally historical type of term, and it basically stands for the fact that there are just simply some contracts that must be in writing to be enforceable. Okay, you cannot get around it. Contracts involving interest in land, contracts that extend out for a long period of time. So, for instance, if you were having a major construction project that was going to last more than a year, it's got to be in writing. And then also, when we get to talking a little bit more about the Uniform Commercial Code, which governs modern contracts and businesses, then contract for sale of goods priced over $500. So what I really want y'all to know is that, again, going back to some of the aspects we talked about with certain contracts, some of them by law, called the Statute of Frauds, simply must be in writing. And when they're not, it creates problems with enforceability. And you can kind of understand the logic behind wanting certain things memorialized in writing. Okay. All right, that's actually everything with chapter 9, and that I wanted y'all to know, just some basically capacity, legality, enforceability. And then I'm going to go ahead and close this one out. And immediately we're going to roll into chapter 10 and look at some different topics. So hope you enjoyed this short lecture, and I will get this posted.